If you've been named as the personal representative of an estate, this video is for you. For most people, this is a once-in-a-lifetime responsibility. On first blush, the job seems straightforward. Your job is to gather all of the decedent's assets, evaluate debts and claims against the estates, pay the valid ones, distribute assets to the devisees or heirs, and accurately and timely complete all the paperwork required by the court. As with so many things, though, actually doing the work of a personal representative isn't so easy, and there are many potential traps. Let's discuss those traps and tips for avoiding them so that you can more confidently take on the PR role. First, failing to identify and gather all of the decedent's assets. It's critical to account for all bank accounts, investment accounts, stock certificates, real estate, and valuable personal property. Missing assets once an estate has been closed forces the probate matter to be reopened in the court. To avoid this problem, take sufficient time to thoroughly review the decedent's recent tax returns, bank and investment statements, mail, and digital assets. Keep meticulous records. Second, confusing probate assets with non-probate assets. Many estates have both probate assets and non-probate assets. It is extremely important for the personal representative to categorize assets correctly. Basically, assets with valid beneficiary designations or jointly owned assets are non-probate assets. Including these assets as probate assets causes wasted effort and mistakes. Avoid this problem by learning which assets pass outside probate. Confirm beneficiary designations and ownership early on and before starting the probate court paperwork. Third, being too casual with estate funds and accounting. Being a PR carries serious management responsibilities. Moving or holding estate funds in your personal account looks bad, even if they're accurately accounted for, and it can create legal penalties and personal liability. Instead, open a dedicated estate bank account as soon as possible. Deposit all estate funds and pay all estate expenses from this account. Keep clear records and monthly reconciliations. Fourth, being unfamiliar with terminology, technicalities, or processes. The administration of certain estates requires compliance with complexities such as disclaimers and portability elections. A PR may not be familiar with these terms, but unfamiliarity will not excuse a PR's mistake. Avoid this by consulting with a professional regarding all legal matters that may impact the estate you are charged with administering. Fifth, improperly handling creditor claims. One of the PR's jobs is handling valid debts against the estate. When the estate is fully solvent, this can be fairly straightforward. But even so, and then especially if the estate is insolvent, the proper payment of creditor claims is a minefield. The statutes set out a priority schedule for paying claims. Handling this incorrectly can leave the estate liable and expose you as the PR to personal responsibility. Address creditor claims by publishing required notice in a newspaper, yes, old school. Respond to creditor claims promptly, and consult counsel before rejecting or paying any disputed claims. Sixth, failing to exactly follow the terms of the will. The terms of a decedent's will can sometimes surprise heirs. When distributions are not as the heirs expected, the PR will definitely hear about it. Regardless, it is the PR's job to carry out the decedent's wishes as expressed in the will. Doing otherwise can subject you to personal liability. If, for some reason, the terms of the will are impossible to carry out, seek and obtain an order from the probate judge to guide your actions as a PR. Seventh, failing to control the distribution of personal property. Now, this is difficult, but to the fullest extent possible, do not allow people to just go in and take the things that they may want from the decedent's home. Do not decide on your own who gets what. Rather, develop and stick to a system for distributing the personal property. Get appraisals for anything of significant financial value, and consider having all the heirs sign an agreement regarding the distribution of personal property. Eighth, making distributions too early. In many cases, the heirs will start requesting that the PR pay out their share very early on in the process. The problem is, if valid debts or tax liability arises after the funds have been paid out, then what does the PR do? It's very difficult to get distributions back once they've been paid. If estate funds are distributed too early, the PR may then be personally liable for paying these debts. The solution? Resist the demands of the heirs. Maintain an adequate reserve until you are sure that all debts and tax obligations have been satisfied. Ninth, a final tricky point, not fully understanding your fiduciary duties. There is a lot to do in administering an estate, and it can be overwhelming for a PR, especially if that PR is also a grieving family member. Regardless, the PR has an overriding legal duty to act in the best interests of the estate at all times. This includes the duties of fairness and transparency. You must take actions in a timely manner and keep the heirs advised of matters that impact the estate. Small delays on many tasks add up and can turn a normal probate into an ordeal. Also, not keeping the heirs up to date leads to many questions and can even breed suspicion. These problems can be avoided by treating your PR role as a project with deadlines. Make a timeline, set weekly goals, seek assistance when needed, share the timeline with the heirs, send them regular updates, and let them know if an unanticipated issue has come up that will take time to resolve. Being an executor is a big responsibility. Being aware of the traps we discussed today and how to avoid them will save you time, money, and family relationships. Thank you.